So today I spoke at the HR Law Masterclass on managing workplace injury and return to work. I think some of the reasons that it's such a difficult area to manage for employers is because of all the overarching obligations an employer has to comply with. Not only legislative obligations in respect of safety, anti-discrimination laws, workers' compensation laws, but also looking at the right to ask an employee to attend the independent medical assessment. I think where sometimes people go wrong is when there are claims later brought into court arising from these issues, is where employers don't have sufficient evidence for the decision making they've taken during the process, or where they've relied on medical evidence which has maybe come from a GP rather than a specialist who can really assess the capacity of someone's ability to return safely to work. So I think the key point I would say is to keep in mind looking at the entire context of the employee's capacity in the context of the role that they perform, but also in the context of their employment situation. What does their contract of employment say? Is there an industrial agreement or instrument that covers them? What does that say in relation to periods of illness or absence from work? And making decisions based on that are objective and reasonable.